right, welcome. Looks like we're live here. This is Freedom is Scary, episode number 52. Today's Monday and almost the end of March. It's hard to believe it's been almost a year since really the apocalypse started. Now, Thomas Jefferson said that none but an armed nation can dispense with a standing army. He said that in 1803. Now, he was one of our founding fathers, right? I think we all can agree on that. Now, why would Thomas Jefferson have said that an armed citizenry could replace a standing army, which clearly our founding fathers didn't want? If you haven't studied history, we weren't supposed to have this huge army, this huge military. For obvious reasons, if you look at military coups across the world, throughout world human history. If Thomas Jefferson and his colleagues just meant for us to be able to duck hunt and to hunt Bambi, and that's what they really meant with the Second Amendment, then why was there this idea that we would have protection for this new constitutional republic by the citizens being armed? And they weren't supposed to be armed just with shotguns or just with hunting weapons. I mean, it was armed with the military weapons of the day. If you read anything that the founding fathers wrote, that's what it was about. And be very wary of what's going on right now. Just look at human history. To rule as a tyrant, there is no other way to do it but to disarm the people. The fact is how could an armed nation, an armed citizenry, take the place of a standing army? So a government governed by the consent of its people, it requires and it's aided by the concept of the citizens being armed. So if your government rules over you with consent, if you have consent, if you give consent, then therefore you must be able to withdraw that consent. And how can one withdraw consent but through the actual or the perceived capability of bearing arms against enemies, whether foreign or domestic? You know, C.S. Lewis said that history isn't just the story of bad people doing bad things, but it's quite just as much the story of people trying to do good things, but somehow going wrong. And that's the whole basis of the concept and the rule that freedom is scary. It's not because it's good to live afraid, but it's because that one must free themselves of the chains and the slavery. That is the price that you have to be willing to pay to purchase safety. Or to put that perhaps more logically, chains and slavery is the price that one must pay to purchase their perception of freedom or perception of safety. So with safety comes chains and slavery. Freedom is scary. And like Patrick Henry said, Almighty God, I know not what course others may take, but as for me, give me liberty or give me death. And I believe as he said that, I think during the speech, he didn't have a knife handy, like this 18th century knife, but he picked up I think it was a letter opener, and he sort of plunged it into his heart as he said it. And the crowd just completely went silent. And that's the point. Is I don't care what others want to do if they're willing to give away their liberty and their freedom just to purchase what they perceive to be a little bit of safety, but which is not. The entire concept of our country was, in order to have a free country, we're going to have to live in a more dangerous place. And so where else has that been proven but now in 2021, United States of America? So it's the same government that acknowledges that it refuses to protect us, that it's incapable of protecting us and that it will not protect us, now has resumed the procedure of every tyrant in human history. And that is, for a tyrant to subjugate its population, it must disarm it, not only of physical weapons, but also of ideas. The fact is that they're unwilling to defend your lives. They're unwilling to defend your businesses just to participate in this new religion of wokeness. They're unwilling to allow even the slightest bit of dissent or the slightest bit of variance in personal opinion or free thought or critical thinking. The fact is that the primary weakness of civil rights, or civil rights as we know them in America, is that only the so-called government can violate your civil rights. So you can't generally sue private parties for violating your civil rights. You have to sue the government or government actor, government employee, government official. And isn't this what we're seeing? Where else does a tyrant in 2021 turn to violate the civil rights of the American people? They're going to turn to the corporations and the private organizations who will deny you access to public education, deny you access to private education, deny you access to be able to practice your religion, deny you access to private banking institutions, deny you access to healthcare of your choice, deny you the ability to express your free opinions, deny you the ability to be employed or to have a job, deny you the ability to defend your property, deny you the ability to defend your country, and lastly, deny you the ability to even defend your life. So it's our founding fathers knew very well the danger of the bureaucracy under the executive branch of the federal government, and the danger of growing that and allowing that to creep into the domain of the other two branches. And that's that's exactly what's being talked about here in the decision that came out of the Sixth Circuit U.S. Court of Appeals. I believe it came out late on Thursday of last week. And that's the GOA versus Garland case. Now, that is also known as the Bumpstock case. So we just got two big decisions that came out of the Federal Circuit Courts of Appeals. One is the awful decision that we got out of the Ninth Circuit and the Young versus Hawaii case, and finding that, according to them, there's no Second Amendment right at all outside of your home, because their opinion is, looking at their false historical analysis, that you have a right to have a pistol in your home. And they wouldn't even give you that if they had the choice. But they're forced to say that because of the Supreme Court decision in Heller in 2008. But they say you have no right to bear arms whatsoever, regardless of what the Second Amendment actually says. No right to bear arms at all outside of your home. And you can watch the last video for my rant on that. But fortunately, we got a good decision also last week, and that was out of the Sixth Circuit. Now, the Sixth Circuit, I'll put up my handy map. The Sixth Circuit is based out of Cincinnati, Ohio. So there, if you're in Ohio, Kentucky, or Tennessee, and I just barely missed the Sixth Circuit, and I'm in the Fourth Circuit. But the Sixth Circuit has a lot of great gun rights stuff that has come out of it. So that's where this opinion came out of. So if you're in Ohio, Kentucky, or Tennessee, if you're in the Sixth Circuit, or actually we have Michigan as well. I didn't even realize Michigan was in the Sixth Circuit. So if you're in one of those states, you're in the Sixth Circuit, this is applicable to you. So ideally, it goes to the Supreme Court and becomes applicable to all of us. But this wasn't really a Second Amendment case per se directly. This had to do with the bureaucracy, with the ATF being able to basically create legislation to say that, you know what, bump stocks, we're going to decide now that bump stocks are illegal. We're just going to say that they fall within the definition of machine gun under federal law. So Congress didn't create any new legislation on bump stocks. It was just the ATF bureaucracy, just on its own, decided to now outlaw bump stocks. And that was at the direction of the Trump administration. And that's why a lot of Second Amendment advocates are, sort of became never Trumpers. And that's because Trump went after the bump stocks. Now, this was after the shooting that took place using bump stocks at the where was it? At the out of the hotel when the country music festival was going on. But what Trump didn't realize, and what a lot of people didn't realize, what the NRA didn't realize, because they sort of encourage this, is that it's always a slippery slope. I mean, how intelligent do you have to be to understand that constitutional rights are always a slippery slope? If you let them go after bump stocks, then you let them go after the next thing, and then the next thing, and then the next thing. So it was never really about bump stocks. This case was filed by the several different advocacy organizations and individuals, but primarily filed by Gun Owners of America. And they've been doing a great job and really getting down in the trenches and litigating these gun rights cases. And they were the primary plaintiff on this case. And it went through the trial court level and then makes it up to the circuit court level. And that's what was issued here this past, let me bring it up. That's what was issued here this past week. And I'll go through the decision with you. So here we go. United States Court of Appeals for the Fourth Circuit, for the Sixth Circuit. I'm used to saying Fourth Circuit. But these are all the plaintiffs, Gun Owners of America. And if you're looking for a gun rights organization to donate to, that's what I do. Donate to the Gun Owners of America. They are down in the trenches fighting these cases that even the NRA won't fight. And it's a good thing that they will. And they also acknowledge that it's not just Second Amendment litigation itself that's important, but also Fourth Amendment litigation. Because a lot of our great gun rights decisions came out of Fourth Amendment cases that may or may not directly involve firearms, but you protect all these, every interaction between the government and the individual. That may be necessary to protect gun rights when you live under a legal system that says you don't have a right to bear arms outside your home, depending on which circuit you live in. So the question in this case that went up to the court was, it's complicated, but it's simple. It's whether a bump stock can be classified as a machine gun under the federal statute, and that's 26 USC section 5845B. But it's basically the definition of a machine gun. We have since 1934, it's been not illegal to own a machine gun, but you have to have a stamp for it. You have to basically jump through the hoops, pay the tax, and have a permit for it. So what they try to do is just say, well, this new gadget, this new bump stock thing, we're just going to say that since it sort of makes a semi-automatic rifle look and sound like a machine gun, we're just going to say it is a machine gun. And ultimately, that's what was at issue here before the court. And the opinion's a really good one. It's not as long as the 215-page opinion, the awful Young versus Hawaii decision that I looked at in the last video. This is still a long opinion, but it's a much, much better one. So December 26, 2018, that's when the ATF came up with this new rule that they're now going to classify bump stocks as machine guns. And they reversed their position several times. So the plaintiffs filed suit here. We have 3 gun rights organizations, 2 individuals who own bump stocks, and 1 individual who would purchase one if not for the final rule. So they hit all their bases as far as proper standing. So you've seen that the courts will kick you out on standing if it's a controversial issue or they want to avoid ruling on the issue, they can just say, like the Supreme Court did to Trump, well, you lack standing, or to the attorney generals who are challenging some of the election problems. Well, you don't have standing. So they hit their points of standing, and they got through that. So a lot of this has to do with what you'll see here, Chevron deference. So what is that? So Chevron deference means Chevron is a case. That's just a case that the Supreme Court held that where, and we'll get into this, but basically where a statute from Congress is capable of being read in different ways, will defer to the agencies such as the ATF and how they want to read those. And it's basically, we'll defer to the ATF. If the ATF, and that's what's been said in past decisions, if the ATF wants to decide that a machine gun is X, Y, or Z, well, we just have to defer to them. But that's the problem with that, is that's basically allowing the ATF to create legislation. And is that not a separation of powers violation? Because we elect these people that go to Congress, and well, who are we to complain to? Congress didn't outlaw bump stocks. It was just the ATF with unelected bureaucrats who live in Washington, D.C. or in Northern Virginia. So this had to do with Chevron deference. They go quickly through some of the history of gun control in the context of machine guns through the 20th century. And a lot of people don't realize a lot of this. But there's a lot of good stuff in here. Look, for instance, for as long as there have been firearms, there have been efforts to make them shoot faster. Of course, why not? The modern day machine gun dates back to the 19th century with the Gatling gun, 1861. That was hand cranked. Then you have the 1884 invention of the fully automatic Maxim gun. Somewhere I have a picture of me shooting one of those. So here's where things went wrong. Trying to crack down on the criminal use of concealable, high-powered firearms, Congress passed the National Firearms Act of 1934. So this is after the Roaring 20s. We had all the gangsters with the Thompsons, the Tommy guns, and of course, something has to be done, and politicians always have the answer. So that's what we got, 1934, the National Firearms Act. Just like 9/11 happens, and then we are bestowed with the Patriot Act, or whatever they'll give us this year. Anytime there's a problem, the politicians are going to fix it, and guess what happens? We, the people, we law-abiding citizens, lose freedoms, and the government gains power. You have this, the ATF now has all this power, and the federal government has all this power. And look, they're keeping machine guns out of the hands of what's supposed to be an armed citizenry, supposed to be able to take the place of a standing army. But now it's hard to do that because we're not allowed to, at least without the government's permission, now own certain sorts of weapons, such as the machine gun. So this was the first real major federal attempt to regulate firearms. And at that time, it was a $200 tax, and that was supposed to make it difficult to buy a machine gun because you had to pay this $200 tax. And in 1934, that amounted to about $3,800 of today's money, but it's still $200 tax. And isn't that what government always does? If it wants to get rid of something or reduce something, it just increases taxes on it, or it increases regulations. It's like what the Democrats want to do to coal mining, to the coal industry. They want to make it unprofitable. They want to increase the taxes. And that's what they've tried many times to do with guns. And there's a long history of that. But that's what they were doing in 1934. So 30 years later, 1968, you had all the Kennedy and Martin Luther King's stuff going on. You had the Gun Control Act of 1968. Obviously, that provided safety for every American citizen, right? Which, among other restrictions, prohibited felons, drug users, and the mentally ill from purchasing firearms. So their definition in the 1968 Act was largely taken from the 1934 Act. So this is the definition of machine gun that was in these two acts. The term machine gun means any weapon which shoots or is designed to shoot or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any combination of parts designed and intended for use in converting a weapon into a machine gun, and any combination of parts from which a machine gun can be assembled if such parts are in the possession or under the control of a person. So next thing that happened really is 1986. Congress passed the Firearms Owners Protection Act. They always name these things completely opposite of what they actually do. Firearm Owners Protection Act. Basically, it's the government and Politicians Protection Act, which was disarming actual firearm owners and actual United States law-abiding citizens, which banned civilian ownership of machine guns manufactured after May 1986, as well as any parts used to convert an otherwise legal semi-automatic firearm into an illegal machine gun. So, for instance, before 1986, you could buy, say, a Colt M16 fully automatic machine gun rifle for like $1,500. Now, since post 1986, any machine guns that were manufactured into M16s after 1986, they were banned. You couldn't buy them as a U.S. citizen, even if you paid the tax stamp and went through all the hoops. So therefore, what happened? Due to the laws of supply and demand, now instead of $1,500, that same M16 is now worth $20,000, $30,000, or maybe even more now. So it just severely restricted and limited the supply, and it's just another way of not outright banning completely, but just severely restricting the people who could afford it and severely restricting the supply of it. So looking back at their definitions in the 1986 law, it amended the definition of machine gun by striking out, quote, any combination of parts designed and intended for use in converting a weapon into a machine gun, and inserting any part designed and intended exclusively or a combination of parts designed and intended for use in converting a weapon into a machine gun. So they're trying to get at things here like parts that can be added, like what they would call like a sear that you could install into an otherwise semi-automatic, say AR-15 style rifle, and convert it to fully automatic. And that's what they're trying to really outlaw here, is not just guns that were manufactured from the beginning as machine guns, but also items that could be used to create a semi-automatic weapon into a machine gun. So they're trying to make this as broad as possible. And you'll see what happens here. Even though they made the definition as broad as possible, it still is ridiculous to extend it to a bump stock. So this goes then through the history of the bump stock. So the bump firing technique, if you don't know what that is, that's basically just using the recoil of the gun where it bounces back and forth to pull the trigger, to cause the trigger to be pulled faster. So you're not pulling the trigger down and having multiple rounds go off like a machine gun. You're just pulling the trigger really fast and using the recoil of the gun to help enable that. So the technique of doing so has been around for a long time. And in fact, as long as semi-automatic firearms have been around, because as they noted, since the days that firearms were first invented, we've been trying to figure out ways to make them shoot faster, because it wasn't always about target shooting faster because that was more fun, but because sometimes your life or death may depend on it. In March of 2002, the guy who had created this bump stock as we know it asked the ATF whether this thing that he had invented called the Aikens accelerator, whether it would be classified as a machine gun. So initially they were confused, but the ATF confirmed originally that it did not constitute a machine gun. Now, by 2006, the ATF came back, opened an investigation, and said that they were going to overrule their own prior decision that it was not a machine gun. Now it's a machine gun again. And then and this is the court, and this is the Sixth Circuit writing this out. Meanwhile, between 2008 and 2017, the ATF issued classification decisions concluding that other bump stock type devices were not machine guns, primarily because they didn't rely on internal springs or other mechanical parts to channel recoil energy. But then they later reversed course on that as well. And it's always a tragedy that gets used here. So October 1st, 2017, there's the shooting in Las Vegas, Nevada. This guy's shooting out of the 32nd floor of the hotel room, kills 58 people, wounds over 500. He used a bump stock device or devices attached to some of the rifles. Then you have President Trump. He directed the Department of Justice to dedicate every resource they had available to find ways of banning all these devices that they hoped would turn, Trump directed them to outlaw bump stocks, basically. So why didn't he turn to Congress? Why didn't he turn to Congress? He turned to the Department of Justice, the executive branch. So March 29th, 2018, the DOJ published a notice of proposed rulemaking that went after the bump stocks. So the final rule rescinded the ATF's prior classification letters, which were back and forth, permitting some of these non-mechanical bump stocks, or all of the non-mechanical bump stocks, and held that bump stocks must be either surrendered to the government or destroyed by March 26, 2019. Isn't that a scary phrase that I'm afraid we'll see again? Surrendered to the government or destroyed by March 26, 2019. I wonder what's going to come next that has to be surrendered to the government or destroyed by such and such date, to avoid criminal liability, no less. So we don't need to go through all the procedural history of the case. Chevron Deference. So this is what this case really hinges on. It's not an exciting topic, but this is what the ATF and other government agencies, the government itself, this is what they were using to magnify the power of the executive branch, of the bureaucracy, and to minimize the power of Congress, so the power of our elected representatives, to minimize the Constitution, which requires laws to be passed by Congress, not by unelected bureaucrats. So this is based on a 1984 Supreme Court decision, Chevron USA versus Natural Resources Defense Council. And basically, it just created this concept of deference. So an agency's interpretation of a statute is entitled to deference from the courts. Chevron is rooted in the background presumption of congressional intent, that Congress intentionally delegated interpretive authority to the agency by enacting a statute with, quote, capacious terms rather than plain terms. So if Congress passes a statute that's capable of multiple interpretations, the courts are not going to second guess, or under Chevron, the courts are not going to second guess which of those interpretations the agency chooses to use. So it's Congress's fault, basically, for giving them a statute that's worded in such a way as to be interpreted in multiple ways. So it's just a concept of deference. And so since it came out of the Supreme Court, the lower courts were having to take the position that, well, they disagree with this particular interpretation in whatever case it was, but since the Supreme Court said so, they don't have any choice in the matter. They have to go with the agency interpretation. So that was Chevron deference. And it wasn't intended to do this, but it created what's called a tectonic shift in administrative law, and a tectonic shift in freedom, where it gave these executive agencies like the ATF just a massive amount of power, where it didn't matter what Congress was going to allow or restrict. All that matters is what ATF is going to allow or restrict. So this is how Chevron works. You apply the ordinary tools of statutory construction, and the court must determine whether Congress has directly spoken to the precise question at issue. If the intent of Congress is clear, that's the end of the matter. And it must give effect to the unambiguously expressed intent of Congress. But statute is silent or ambiguous with respect to that issue. The question is for the court is whether the agency's answer is based on a permissible construction of the statute. We don't need to get into the construction of statutes, but it all has to do with whether it's written in such a way as you could have multiple meanings. So when a court reviews an agency's construction of a statute, and the statute is silent or ambiguous, the court may not substitute its own construction. So this limited the lower courts. This is sort of like sentencing guidelines, where the sentencing judge doesn't even have the discretion to give a worse sentence or a more lenient sentence based on the facts of the specific case. He's bound by some sort of other law that restricts the discretion of the court. And that's how this was. But then things changed. In 2014, the Supreme Court said, we have never held that the government's reading of a criminal statute is entitled to any deference. And that was the Apple case, 2014. So is it a civil case or a civil statute or a criminal statute? The way this was challenged it's a criminal statute. So if you have a bump stock, and a bump stock's a machine gun, and that is, you don't have a stamp for that, you're violating a federal statute and you're now a convicted felon. So that's a criminal statute. So what they said in 2014 is that, well, you're misreading the Chevron case. We never said that it applies to a criminal statute. You don't have to give a criminal statute any deference. So that's the complete opposite, basically, of what the federal courts thought in regards to Chevron. Then a few months later, in Abramski versus United States, also 2014, the court said sort of the same thing. In the end, the court was clear, unequivocal, and absolute in saying that it has never held that the government's reading of a criminal statute is entitled to any deference. Unless the court was mistaken in those two cases or exaggerating for effect, that bold, absolute statement, and this is from the Sixth Circuit now, means that none of the court's prior cases applied Chevron deference to an agency's interpretation of a criminal statute. So that's how the court was able to come to its own decision here, is because this is a criminal statute. And therefore, as of 2014, as of those two statements by the Supreme Court, there was a great case to be made that there should be no Chevron deference here. All right, skipped a lot of this stuff. Okay, now what about other circuits? So again, we're talking about the Sixth Circuit here: Ohio, Kentucky, Tennessee, Michigan. Now the other federal circuits, as they note here, they've split as to whether there has to be Chevron deference, or whether a court can make its own decision when they're interpreting a criminal statute anyways. So I'll just note quickly, if you're in the Ninth Circuit, there's a case to read. If you're in the Second Circuit, there's a case to read. If you're in the Fifth Circuit, there's a case to read. Okay, if you're in the 10th Circuit, there's a case to read. And look who wrote that one, Gorsuch. Let's see. Supreme Court is expressly instructed as not to apply Chevron deference when an agency seeks to interpret a criminal statute. There's also a case from the DC Circuit, 2019. Fortunately, no Fourth Circuit case there. Let's see. I don't know if I can put my map back up here. So just again, if you want to see if there's a Chevron case in your circuit, look at the 9th, the 2nd, the 5th, the 10th, and the DC Circuit. Those all have cases going different ways. Now, specifically, they call out the 10th and the DC Circuit. So 10th and the DC Circuit. So if you're in DC or you're in the 10th Circuit, your circuits have each concluded that an administering agency's interpretation of a criminal statute is entitled to Chevron deference. And under that deferential standard of review, they found an ATF's rule a permissible interpretation of this particular issue on 5845B. So if you're in the DC Circuit or if you're in the 10th Circuit, your federal circuit court has said that, look, we don't have any say in the matter whatsoever, and pretty much the opposite of what's happened here in the 6th Circuit. Some interesting stuff here. It gets a little better here. Now, we get into really what our country is all about, and the basis for criminal laws in general, and the basis of separation of powers in our constitutional republic. So they get into some of this philosophy. So our criminal laws continue to reflect our public moral judgment. And where else is this stuff going to apply? As you look at this, where else does this apply but to a lot of the COVID fascism that's going on? Like here in West Virginia, where you've had one man ruling the state for over a year now. Just one man. One man. And we're supposed to have elected representatives that reflect our public moral judgment. Now, has it been reflected? If our governor can say that a barber shop owner can be arrested or should be arrested for not forcing people to wear masks, or even for opening in the, when he's been told to close because of a pandemic. No, there's no public moral judgment underlying that. That is just a decision of one man, really worse than a king. It's just an absolute tyrant, a dictator. But back to the topic at hand. So that's the theory behind our criminal laws at all. And the legitimacy behind that is that it comes from us, the consent of the governed, because we elected the representatives, and then they memorialized our moral judgment into our code of criminal laws. So where does the training come from? Does it come from bureaucrats in Washington, D.C. to be able to say what our moral judgment is and is not? No. The training for these policy determinations does not come from a graduate school education or even for decades of bureaucratic experience. Can you imagine I would have loved to have been a fly on the wall when the bureaucrats in DC and the ATF were reading this. Rather, one develops the expertise necessary to make moral judgment from sources of a more humble and local origin, one's family and upbringing. Now, isn't that a shock compared to what you've been hearing pursuant to the wokeness religion? This learning is further informed by relationships with friends and neighbors, the practice of one's faith. That's really unacceptable nowadays. And participation in civic life. That this education is accessible to everyone and anyone further enhances, not diminishes, the legitimacy of these community-based judgments. That is why, from the founding, the Supreme Court has held that there can be no federal common law crimes and that only the people's representatives in Congress may enact federal criminal laws. And what the Supreme Court has previously said about a federal court's ability to create a crime is equally relevant to a federal agency's ability to do so. Quote, because criminal punishment usually represents the moral condemnation of the community, legislatures and not agencies should define criminal activity. And they continue, the ATF is not an expert on community morality, so the rationale of deferring to agency expertise on this question makes no sense. It fails. There's a great risk if the responsibility of making these moral condemnations is assigned to bureaucrats in the nation's capital who are physically and often culturally distant from the rest of the country. Now, how much sense does that make? Federal criminal laws are not administrative edicts handed down upon the masses. as if the administrators were God delivering the Ten Commandments to Moses on Mount Sinai. Great, great writing here. Whether ownership of a bump stock device should be criminally punished is a question for our society, not for bureaucrats in Washington, D.C. And that really is just a great point. So while you're going through a lot of the Chevron stuff, and it's sort of a boring topic and really down and in the weeds of administrative law and interpretation of statutes, if that's all you see, you're missing the point here. And the NRA, for instance, was missing the point all along. It's not just about Chevron. It's not just about bump stocks. It's about, are we a free country or are we not a free country? Are we going to allow the sacred power of saying what activities will imprison people for years, maybe the rest of their lives, is going to be delegated to these intellectuals in Washington, D.C., who all go together at the same time at 3:30 to the Starbucks on the corner, and who are actually doing very little work during the day? I know, because I work there. No, we don't want to delegate our, this sacred moral duty, I guess you could call it, to these bureaucrats. That we didn't elect them for anything. They shouldn't have any duty but to enforce the laws that our representatives put on the books, not create new ones. And that's what's been happening. That's what this is about. If they could do that with bump stocks, they can do that with anything. And that's really what's been going on. For instance, with the pistol braces, that's the same sort of thing they were doing with the pistol braces. Well, we don't like pistol braces. They were used in XYZ tragedy. So therefore, we're just going to reclassify them as being, under our rules, something that's already outlawed by Congress. That, they didn't exist when Congress wrote that law, but we're going to include it in because it just fits within our parameters. So this comes down to basic constitutional law. Just the basic stuff. Article 1, Section 1. The Supreme Court has permitted Congress to delegate some of its lawmaking responsibilities to the executive branch, so long as they provide, quote, an intelligible principle to which the administering agency is to conform. So government is so big now. There are so many laws. There are so many public entitlements that Congress, of course, can't do everything themselves. So they've been given some ability to create, what they call rulemaking here. So the court the court here admits that in this increasingly complex society, that with the new technology and changing problems, that Congress can't do everything, so they have to delegate some power. Okay, so the Supreme Court has allowed it as long as there's a clear statement or intelligible principle standard, and it's a low bar that Congress can overcome as long as they give pretty good instructions to the agency. So that's what we're balancing with what they're actually doing here. But then you get into the separation of powers. So this is really good. The separate and this is where the COVID fascism is really just illustrated. The separate and distinct exercise of the different powers of government is essential to the preservation of liberty. That's from the Federalist, number 51. The separation of powers serves as the great security against a gradual concentration of the several powers in the same department. In addition to protecting each branch of government from incursion by the others, most importantly, the structural principles secured by the separation of powers protect the individual as well. Each branch's role, that would be the executive, judicial, and legislative, with regard to criminal statutes is clear. First, only the people's elected representatives in the legislature are authorized to make and enact a crime. That's really not how we've been running our country the past year. Next, the executive is responsible for enforcing criminal statutes, and it retains exclusive authority and absolute discretion to decide whether or not to prosecute a case. Makes sense. Finally, it's for the courts to say what the law is, including the criminal law. And that's law school day one, Marbury versus Madison. So basic separation of powers. The legislature creates the law. The executive enforces that law and has the sole discretion about whether they're going to do so. And the judicial branch says what that law means, what it says, where it applies, where it doesn't apply, based on the facts of any particular case before it. And that's the process that hasn't been followed here. First, giving one branch the power to, again, apply this to COVID. First, giving one branch the power to both draft and enforce criminal statutes jeopardizes the people's right to liberty. The concern over the potential abuse of power if the executive can define crimes predates our nation's founding. Federalist number 47. In all tyrannical governments, the supreme magistracy, or the right of both making and enforcing the laws, is vested in one and the same man, or one and the same body of men. And wherever these two powers are united together, there can be no public liberty. So that's where we are today, especially in West Virginia, pretty much every other state. There can be no public liberty. The same group of, the same man or woman is both making and enforcing the laws under the guise of emergency powers. So imagine having a president who would have done that, which we do now, no doubt. If the executive branch wants to prosecute someone for something that is not yet a crime, it should use Chevron Deference to interpret a statute so as to criminalize the activity and then prosecute an individual for doing it. Do you see the problem with this? The slippery slope, the sadisticness of it, the injustice of it. So if the executive branch, let's say if you hate Trump, let's say the Trump administration. If you hate Biden, let's say the Biden administration. Let's use Trump as an example. So if the Trump administration wants to prosecute you, say you're a little Antifa dude. If the Trump administration wants to prosecute you for something that isn't even a crime yet, it could use Chevron deference to interpret a statute that's already on the books so as to criminalize that activity and then prosecute you for doing it. Or we could have the Biden administration and the DOJ under the swamp, and this is real. They want to prosecute, say, Trump supporters for doing something that's not yet a crime, but is supposed to be protected under the First Amendment. They could use Chevron deference to interpret a statute so as to criminalize the activity and then prosecute an individual for doing it. So what are they doing going after all not just the Trump supporters that were at the Capitol on January 6th, but any Trump supporters who were there at the Capitol? So if they want to prosecute you for doing something that wasn't a crime, all they have to do is interpret a statute that is a crime and say they call it insurrection or they call it sedition. Even though it's not, they just interpret it that way. Then they've criminalized activity to create this new crime to prosecute somebody they don't like and they want to persecute. And they're able to do it using this Chevron garbage. So it's even not even about just the Second Amendment or gun rights, but it could be applied to all sorts of things. It could be applied to the First Amendment. So you could lose your First Amendment. And that's what these leftists either don't care or don't realize. They hate guns so much. They hate the Second Amendment so much that they want to do whatever they can to attack it. And the idiots don't realize the unintended consequences that come out of that, where they're going to lose, the rights that they care about as well, such as the First Amendment, which in reality, a lot of them, they only worry about the First Amendment for themselves, which is the same thing. If you deny constitutional rights to anybody, then you can't claim them for yourself when somebody else is making the decisions anyways. So here's the implications. Granting the executive the right to both determine a criminal statute's meaning and to enforce that same criminal statute poses a severe risk to individual liberty. Entrusting the interpretation of criminal laws to the judiciary and not the executive mitigates that risk and protects against any potential abuses of government power. Third, because it's the public's responsibility to determine what conduct should be condemned, only the people's elected representatives in Congress have the power to write new federal criminal laws. Congress alone has the institutional competence, democratic legitimacy, and most importantly, constitutional authority to revise statutes in light of new social problems and preferences. So it's just like the COVID stuff again. If you don't like, which of your elected representatives do you complain to if you don't like the mask mandate, or if you don't like the fact that your business was closed forcibly and you didn't want to close, your customers wanted to come in, say the hair salon, your customers wanted to get their hair cut, they knew the risks, they didn't care, they wanted to get a haircut. You knew the risks as well, you needed money, so you wanted to open. So who do we complain to? Do you complain to your local legislator? No, they had nothing to do with it. So there's no one to complain to, and that's the point. So who could you complain to about the ATF out banning bump stocks? Well, you couldn't really complain to Congress because they didn't do it. All right, so more separation of powers goodness. Of all the separation of powers concerns identified, perhaps this is the most troubling. The bureaucrats at the agency are unaccountable to the public. If the agency adopts an interpretation contrary to the will of the people, what recourse does the public have? Unlike legislators, agency bureaucrats are not subject to elections and are often further protected from removal by civil service restrictions or surrounded by National Guard and by tall fences. Even when an agency implements the will of the public correctly, that determination may still violate separation of powers because the community has the right to determine what moral wrongs should be punished, a practice that predates our Constitution. That responsibility may be entrusted to only the branch most accountable to the people, the legislature, and it may not be blithely delegated away. That's from Locke. And I hate to keep bringing up the COVID stuff, but that absolutely is not the way it's worked. So if it's going to be a crime to not wear a mask, where did we get to have a say in that? Shouldn't it be our job to determine what moral wrongs we think should be punished? Should it be a crime to not wear a mask? Should it not be a crime to wear a mask? Where did we get a say in that? So the counter argument is, well, it's a state of emergency. It's an emergency. They had to take action. Okay, well, it's been over a year. We've been in a state of emergency for over a year in West Virginia and most other states. Certainly an emergency to determine what moral wrongs should be punished should not take a year. Even where, 7 or 8, 9 months have gone by, 10 months have gone by, and then the legislatures came back into session. There's no excuse for our elected representatives not to have said yes or no to these things. Now, it's one thing to take emergency powers related to a forest fire, related to a flood, and you've got to manage resources on the ground and that sort of thing. But to actually say that there is an enforceable law that says that if you're not wearing a mask or if you're not making other people wear masks in your store, that you can be arrested and charged with obstruction of justice or whatever it is. I mean, that is creating this new moral condemnation of behavior, which has happened. And the elected representatives have had no part in it. And therefore, the people have had no part in it. And therefore, we're being governed without our consent. So, whatever the merits, this is the point here, whatever the merits of giving this judicial deference to the agency interpretations, that cannot be extended to the criminal statutes, according to the Sixth Circuit. So they declined to grant Chevron deference to an agency's interpretation of criminal statutes, and it respects the community's responsibility to make those decisions on their own, on what should be criminalized, and that upholds the separation of powers. And that definitely is the constitutional decision right there. That's deciding for the people and against the government. That's the job of the judiciary when they do it right. So, but because the ATF's interpretation of machine gun is not entitled to this Chevron deference, then they themselves now get to go into, well, is this bump stock a machine gun? So then they go into that. So they go into the, how you interpret a statute. And I won't have to go through all of them, but this is how technically how it's done. So there's all sorts of formal rules about how they're going to do it. Now, if the definition says single function of the trigger, so you pull the trigger one time and you have multiple shots, that makes sense. That's logical when defining a machine gun. And I don't know how we got so far off the rails. If you pull the trigger one time and it goes off multiple times, okay, machine gun. If you pull the trigger multiple times and every time you pull the trigger it goes off, well, that's by definition not a machine gun. That's semi-automatic. I found this pretty interesting. I didn't realize it when interpreting the words of a statute. So you look at dictionaries, not necessarily now, but you look at the dictionary as of the passage of the statute. So if you look at the main definition we're dealing with from the Gun Control Act of 1968, so they're looking at dictionaries circa 1968. I don't really know what the differences were, but interesting sidebar. So now at this point they go through defining what is a single function of the trigger, and they define words like action. And this was a good point, I thought. The federal definition of machine gun, if you read it, it describes the firearm. So it doesn't describe you as the shooter, doesn't describe what your body does or your body parts do, what your finger does or what your shoulder does, or your actions at all. The entire definition of machine gun under federal statutes focuses exclusively on the design and capability of the firearm. Doesn't mention anywhere else what the shooter's doing or how he's doing it. So, how can ATF extend that to now, all right, now they're going to apply it towards the shooter and what the shooter's doing, when the statute doesn't say that. So it was a mechanical process in their determination, and therefore we conclude that a bump stock cannot be classified as a machine gun. That's the whole point here, under 5845B. So we recognize that a bump stock increases a semi-automatic. So this is where they're going to say, we recognize that it's scary, but freedom is scary. And if you're that scared, get your Congress critter to vote to outlaw bump stocks. But until you do that, we're going to follow the law. So a good decision. We recognize that a bump stock increases the firearm's rate of firing, possibly to a rate nearly to equal that of an automatic weapon. With the bump stock attached, however, the trigger still must be released, reset, and pulled again before another shot may be fired. A bump stock may change how the pull of the trigger is accomplished, but it does not change the fact that the semi-automatic firearm shoots only one shot for each pull of the trigger. And I mean, all of that for something that really is so obvious, but that's how you had to do it, how they had to do it, given the way things were done in the past, with all this overcomplicated Chevron stuff that the ATF gets to have all these deferential rulemaking powers. And, they had to get back to the basics, back to the Constitution, back to separation of powers. And this is also a good point, because if your question is, well, what does that mean? Are bump stocks now legal? Are they only illegal in the Sixth Circuit? So Congress, this is this is the point. If we're going on separation of powers, that means that through the legislatures, these still can be banned. Because this is not, the issue here was not, does it violate the Second Amendment to ban legislatively bump stocks? Do we have a Second Amendment right to have bump stocks? That was not the issue. Congress could amend the statute tomorrow to criminalize bump stock ownership if it wished. Indeed, some states have done that. So are you in these states? These are the states that have passed legislation in their state to criminalize, to prohibit bump stocks. Delaware, Rhode Island, Washington State, missed this one, but New York, of course, Nevada, California, Maryland, New Jersey, Florida, unfortunately, isn't that sad? Hawaii, Massachusetts, and missed this one also, Vermont. So if you're in any of those states, your state legislatures have already banned bump stocks because they had to do something, right, to save the children, because all they have to do is ban bump stocks, and then all of the mass murderers will follow their rules, because, you know, it's not like murder is illegal. So if all they have to do is pass a law that says they can't do it, and it won't happen. But we as judges cannot amend the definition of machine gun under the federal statute. So that's pretty much it. The rest of this opinion here, they go through, the factors of preliminary injunctions. And preliminary injunctions are, there's, instead of going through the whole trial, you can get a injunction to, stop to stop a party or government agency from doing something on an expedited basis by showing that you're probably going to win the case, and there'll be irreparable harm if it's not granted, but that applies in all of these cases. So I skipped most of that. So that's pretty much it. That is the GOA, Gun Owners of America versus Garland, if you recognize that name, Merrick Garland case that was just issued on Thursday. And you may have heard it as the bump stock case. So again, if you're in the Sixth Circuit, there, that's where this case came out of. So if you want to donate to the cause, I put it on my website at thecivilrightslawyer.com, the link to where you can actually donate to this specific litigation, because it's ongoing. It's still going on, and they have some great lawyers. I think it's Robert Olson who litigated this, and I talked to him before about our Walker case. It's at the Fourth Circuit, and he's a fantastic constitutional lawyer, and that's where I would recommend donating to. And I'm not just knocking the NRA, but just look at bump stocks. Look how far they missed the mark here. They said, all right, let's just sacrifice bump stocks to get them past this last tragedy. Let's just sacrifice bump stocks now, and we'll get through this. It's not that the NRA wanted to sacrifice bump stocks, but they had made a tactical decision, I'm speculating, to just sacrifice the bump stocks, and then we'll live to fight another day. The problem is you can't give these people an inch, because they'll take a mile. Okay, let me look at some of the questions here. I have a couple other topics I wanted to hit as well. Jeremy, freedom should always remain scary. No one but you can protect you. I can't imagine anybody doesn't realize that after. It's like they've moved on and they've forgotten the images of all these businesses burning down all year last year, or all summer last year, and the police taking a knee, doing nothing to defend people's lives and their property. I mean, ask the roof Koreans. I mean, we've known this since 1992. The roof Koreans had detachable magazines, semi-automatic rifles, and successfully were able to defend their properties. And now that they're on the topic of of racism against Asians, supposedly by white supremacists. Well, let's look at the roof Korean example, and they established just how American citizens can defend themselves when the police are unable or unwilling to do it for them. And that is by arming yourself and being that armed citizenry that not only is supposed to withstand rioting in these various cities, but we're supposed to be able to withstand foreign enemies invading our country. That's the whole idea, is we're not supposed to have this standing army. Bubba, the problem is in places like Ohio, they've been forced to allow people to have handguns, but have banned people from carrying them in cars. So that's just another way of making them illegal. Yeah, having traveled to Ohio in the past several years, fairly frequently, that really drives me nuts. That used to be something that growing up in Florida, going to college in Florida, that we had to deal with. And I remember getting my concealed weapon permit years ago in Florida when I first was able to, because it was very tricky as to how you could transport firearms in your car. And there were people always getting arrested left and right from transporting firearms in their car. In Ohio, to say that you can open carry as a pedestrian, but you can't open carry in your car, there's no logic to that. And there's also, that creates this physical impossibility to where you can only be able to defend yourself in public if you walk there, which is counterintuitive. So if maybe you have to go through a bad neighborhood to get to the restaurant that you're wanting to go to, well, hell, you probably can't have a firearm in a restaurant that has a bar in Ohio, but anywhere you're going. So you've got to walk and therefore be more susceptible to criminals than take a car where you can drive around it or drive through it. Who is that to protect? But it's just something that law enforcement has lobbied for. Behind a lot of this stuff has been law enforcement, not necessarily the guys on the ground, so to speak, but the leadership, the lobbying wing of law enforcement, the police chiefs, and which goes right along with the mayors and all that. I mean, they've been behind a lot of this. JDaz, ATF recently arrested a guy for selling an outline of a lightning link on a metal card called an auto key card. Apparently, they've made another item illegal just based on appearance. Yeah, I was following that. If it's the same card that I was following, I guess it probably is. So what he's talking about, it was like a product that this guy was selling on a website, selling them online, and it was like the shape of a credit card, but there was a design. So it was basically art, but it was a design of something that technically is in the same shape as, I think it was as some sort of sear or drop-in device that you could use to convert a semi-automatic weapon into a fully automatic weapon. But it wasn't like pre-prepared, wasn't cut out. It was just sort of a design. I guess it was sort of pushing the limits here to see what the ATF would do. And, they came after that guy. They also, I mean, hell, they've come after the so-called ghost guns. So anything that we, the peasants, could technically, using our skills and our tools, turn into something that would make an illegal machine gun, we're not allowed to have those. But yeah, I mean, according to this opinion, I mean, it's spot on that if those things are going to be illegal, then Congress needs to say it's illegal. And then we can complain to our Congress critters, or we can file lawsuits and challenging the constitutionality of the legislation. But the way it's been everywhere except for now in the Sixth Circuit is that when you file the lawsuit, they're just going to say, well, Chevron deference to these agency determinations because they determine that it's a machine gun. Duke It's logical to regulate arms in a police society. I don't know if first I thought you said polite society. It's logical to regulate arms in a police society out in the community, but to restrict arms that is boldly carried in public on private property that is set to one's own security, I guess to be continued, is a stepping stone to tyranny. Well, that kind of goes back to the other decision last week from the Ninth Circuit. So if we have a right to keep and bear arms, and Congress, shall make no law infringing on that right. Well, how do you bear arms? I mean, does that only just mean bear arms on your private property? And if they tie it to being able to engage in the ancient right of self-defense, the natural right of self-defense, then, why wouldn't you be able to engage in that right on public property or off of your own private property or outside of your home? I mean, that goes without saying. And had they covered history properly, it would show that we traveled with our firearms in the 18th century. Hell, they even traveled with their firearms in England. Of course, you're supposed to bear arms outside your own property. All right, TC, laser etched. Okay. So basically laser etched art that just happens to be in the design of something or something illegal could be made out of. I mean, it illustrates the absurdity of where we've ended up with our 5,000 plus federal laws. That's just from Congress. How many other federal laws do we have from these agencies? I don't know what illegal means. I know it doesn't mean unlawful. I don't think I've ever heard you say that before. I don't even remember if I'm saying illegal or lawful or unlawful or lawful. The government only wants to ban a citizen's right to own guns because they plan on doing things that would make the citizens use of them to defend their rights. Well, I think they saw on January 6th the importance of the right to keep and bear arms. I mean, when you had a couple hundred people take over the Capitol who were completely unarmed, like flags. What would have happened if you just had a couple hundred people who were armed with any firearms, much less with more capable firearms? They could have done whatever they wanted. They could have engaged in an insurrection. I think that scared a lot of the elites, a lot of the ruling class. Bill, I saw pictures of the poor people in Myanmar trying to fight tyranny. Is it Myanmar? With bows and arrows and throwing rocks. That's where we're headed if we allow gun control. I mean, absolutely. That's it just goes without saying. I mean, it's happened over and over and over again. Hey, John Lennon. Appreciate that. I think I read something about John Lennon being a gun owner. I know he lived in New York City. I can't remember whether that's true or not. I had a conversation with my son about this. I have to look back at that. All right, Garrett Lucas, what other constitutional right is limited in your home? Well, that's a good question. The Fourth Amendment is bestest in the home. First Amendment in the home. The case I just filed against the family court judge that made my client turn off of his recorder and searched his house. We also made a First Amendment claim in that case because most of the cases, when it comes to the right to record the police, they all pertain to public property. So is there a constitutional right that's clearly established to record the police, the videotape the police on public property? That's what all those cases are. But really, you won't see really any of them about private property. And this is one of those, private property, because it sort of goes without saying. Of course, you have the right to record whatever Well, I guess not whatever you want, because there are things that are illegal to record, but to just walk around and record on your own property. Now, an important aspect of those cases also is that to invoke the First Amendment, it's not just that you're recording, like you're recording the flowers in your yard or something, but you're recording your government officials in an attempt to hold them accountable or be able to show the public what they're doing. But yeah, the Second Amendment should apply. I mean, it shouldn't be any. I think it's the same sort of thing. It shouldn't be any of their business whether you want to bear arms on your private property or in your home. The whole point is in public. Like, you can possess the things and you take them out in public or wherever you need to go to protect yourself. Mark Maloney, that's exactly the point of trying to make here, or have been trying to make, is that we weren't supposed to have this huge military, this huge standing army that, now is concerned and obsessed with itself of see who can be the wokest general. We were not supposed to have this standing army that was putting on PowerPoints constantly of how to be. They weren't having the ones about less white, I don't think, but basically the military, from what I've heard, is they're trying to root out anybody who's conservative. So if you're conservative, or you're a Trump supporter, or you're a gun owner, or you have AR-15s, you are an extremist. You're an extremist, and therefore you're basically a nationalist, and therefore you're basically a white supremacist. And we don't allow people in the military who are part of extremist organizations. And you know what? We weren't supposed to have any of it anyways. I mean, if we got a war going on, then yeah, but we're not supposed to have a standing army. That if we don't have a war going on, we don't need an army. We're not supposed to. We have an armed citizenry, and that will be able to repel any foreign enemies from even attempting. So it wasn't meant for hunting at all. It was meant for bearing military capable weapons. In fact, in the other room, I have some military, privately owned, military used weapons that were used by early Americans, before our country was even created. I was going to show one of them, and I have the original powder horn that comes with it. So this is a powder horn, but this was from the one out there was used in Virginia and in early Kentucky, but the powder horn was huge. I mean, it was huge because you had to have like at least a pound of powder by law in your personal possession to defend yourself and to complete your militia service. So it was one and the same. All right, Terry, let me see if I follow you here. Yes, bump stocks are not machine guns, but they should be regulated as such because they convert a semi-gun into a machine gun. I don't know if you're quoting someone else there or not. No, they're both not machine guns, and they also don't convert a semi-automatic gun into a machine gun. And if you read the decision, the court explains why. But you do have a point that if you believe that they should be regulated, then that's for Congress to regulate or for your state legislature to regulate. But if they're not going to do it, it's not up to the ATF to say, what new gun parts they're going to start defining as machine guns. But I mean, okay, say you do ban bump stocks, and is that going to prevent mass murder in the future? No. Hell, you could ban all guns and it's not going to prevent mass murders. You'd have to ban trucks and cars. And in fact, those are probably used more than anything, especially in Europe. And you're just not going to be able to do it. You can't prevent tragedies like that from going after the objects that are used in the tragedies. And they know that. It's not about that. It's about the policy goal of disarming the public. That's what it's about. I mean, they've been trying to do that for a long time. The ATF seems like they're out of control or being led by progressives. Well, they are being led by. When I had John Crump on from the GOA, he was we went over who Biden had put at the head of the ATF. I don't recall who it is, but basically it is a leftist, extremist, anti-gun individual. So yeah, you could say that they're progressives in charge, but it's just like the FBI with Comey and that bunch in charge. I mean, it doesn't matter. They might say they're Republicans or Democrats, but they're all big government statists, swamp creatures. I mean, they're for big government. They're for an authoritarian power being wielded on the citizens. I mean, I think they're all like that. Okay. Garrett, you misunderstood what I asked. The right to free speech isn't limited to just your home. Neither is the right to counsel, your right to be secure in your person. Why should the second be limited to the home? No, I understand what you're saying. I agree with that. But that's not how the Second Amendment litigation has gone. So they go back to Heller and they look at the framework that was laid out by the Supreme Court in Heller, having to do with guns that were commonly in use at the time and this historical analysis. I mean, it's all a bunch of BS. It's not how it should have gone. But for the longest time, they didn't find any Second Amendment right. I mean, when I went to law school, they made a point and loved to teach that the Second Amendment had never been applied to the states. It only applies to Congress. That's what it says. While other amendments apply to the states, the Second Amendment doesn't. No Supreme Court has found that the Second Amendment applies to the states. I mean, the liberal professors love to say that, and they love to just cheer about that. Then in the McDonald case, it finally was applied to the states. So it's all sort of smoke and mirrors. I mean, but the Second Amendment is the most really clear and unambiguous amendment that there is. John Smith. To your point about the government getting scared after January 6th, isn't this what informed citizens always knew? The citizens are powerful together. We have the right to remove unjust leaders. Yeah, absolutely. I think what was revealed is just how easy it would be. If, for instance, you had the march on the Virginia state capitol a couple of years ago, and you had thousands of patriots there openly carrying AR-15s, and even one guy with a 50 caliber Barrett. And was anybody hurt? What was that? Was the Capitol stormed? No, there was a few of them harassed by the police, and that's pretty much it. They were completely peaceful, and that's how it's always been. Now things went off the ropes on January 6th just a little bit. And, I think there were different groups that were involved and responsible for that. But it's also been blown way out of proportion. The press has been propagandizing that incident, calling it an insurrection and talking about, 6 people were killed. And in reality, it really was the only person killed there. Killed was the Trump supporting woman who got shot, who was unarmed, who got shot in the neck and killed. So it's really been blown out of proportion. Was there riotous behavior, where people were breaking things? Yeah. And how many hundreds of other times, if not thousands of other times, has that happened? But for some reason, this is like the 9/11 of our era. And it really wasn't. And had any small group of people wanted to do that, it would have been done. Terry, your personal right to guns is enshrined within the Declaration of Independence. And you know what else was in the Declaration of Independence, since I can't stay away from the COVID fascism, is, they had the 27 grievances against England. And it was mostly economic stuff. I mean, we were pissed about just high taxes and unfair, economic policy. And now look how how far we've fallen. We let the government just lock down our businesses completely. On the topic of the Capitol, that was another thing I wanted to do another video on or go back to. Was, if you recall, I went over the case of the Oath Keeper who was charged, the guy from Florida who was charged at the Capitol, and I actually talked to some people who were in the organization and even lawyers involved in the organization, and learned a lot about it that I didn't know. And so I'd love to do another video on that, especially now that they're really coming after the Oath Keepers. And that's what's scary, because here you have, that's what third world tin pot dictators do, is they go after their political opponents and they put them in prison, or they kill them if they can. But here in this country, obviously, they're going to put them in prison. And look, these federal crimes that they're charging people with, they got, some of them, they've got like 20 years in prison for, just look at, when they go after the usual political prosecution, they'll get, for a campaign donation, or for, some technicality, because a check is written and mailed through the mail. They get you for wire fraud, for mail fraud. Like, each one of those got 20 years. And they can take somebody who is not a danger to the public in any way and put them in a federal prison for the rest of their lives. Very, very scary. The federal government, usually, the reason I don't do federal criminal defense is because, who likes to just lose for a living? When they charge people in federal court, almost always they're screwed. There's not a whole lot you can do. The issue is just, well, under all these complex sentencing guidelines, how many years in prison are they going to get? So it's really depressing. And now the federal, the prosecuting arm, the criminal prosecuting arm of the Department of Justice is scary enough. So imagine that this entire group of it, the strongest probably group in Washington, D.C., is now weaponized by Democrats or the modern American left to go after conservatives. That's exactly what's happening. And they've gone after this, these organizations, the various organizations of patriotic individuals. And one of those is the Oath Keepers. I never really understood everything about them, but they have more of a formal organization than I realized. And they do have a documented history of not engaging in violence or hurting people or anything like that, or conspiring against the government. It had to do with really what they were engaged in was protecting people. You look at everything Antifa's done, especially with last year. You had the Oath Keepers who actually went to a lot of these events where Antifa was breaking things and hurting people, and they, in an organized fashion, a lot of former military, former law enforcement were there with medical supplies, and they were helping people. And I think a lot of the stuff of the involvement of the Oath Keepers that were at the Capitol on January 6th is actually perfectly in line of their past behavior, which was, organizing and using their skills to be at these events, to be able to help their fellow man. I think that's, that, I don't know that it explains. I suppose it could. Even the people that were inside the Capitol, here's what it wouldn't explain. If any of them were on video, or there was evidence that they were breaking the windows or committing violence against any person proactively, aggressively, yeah, that wouldn't excuse any of that. But I haven't seen so far, and I haven't looked at all of it, all of the charges, but I haven't seen anything with any of these Oath Keepers that caught them engaging in that sort of conduct. It just sort of like, well, it fits their narrative. They had the military style gear. They had communications about that sounded sort of military in nature. And so they're using that against them, I think. So I'm going to go deeper into that, because that's really the scariest thing I think that's going on right now, is just this political persecution against any of these patriot groups, where they're going after, conservatives. They're trying to shut down the political opposition. They're trying to shut down dissent. And all they have to do is make them terrorists. Make you a domestic terrorist instead of somebody with a First Amendment right. John Lennon, if the ATF shows up at your door without a warrant, do they have the right to break in and assault you as well as taking your property? No, of course not. So your home is your castle. It's the most highly protected place under the Fourth Amendment, and they can't come in without a warrant. Does that mean that they won't? No. I mean, warrants like one of these domestic violence protective orders. It's a piece of paper. They're going to do what they're going to do, I guess. Legally speaking, when you sort out the rights at the end, yeah, they need a warrant to come in your house. There are two established exceptions to that. They're trying for a third. The main one is voluntary consent. So the ATF can show up at your door and they say, Mr. Lennon, can we come in your house? We just want to talk to you, whatever. If you let them in your house, then they don't need a warrant. That's an exception. Now, there could be a claim that, well, you were pointing your gun at them, or it looked like they had a gun pointed at you. They were super, super threatening. And so therefore the consent wasn't voluntary. That could be an issue. The second applicable exception is exigent circumstances. So that's some sort of emergency. And of course they can abuse that. That could be a physical emergency. Somebody's in danger. They hear somebody being beaten inside, but it can also be in some cases to secure evidence that they know is in the house, like, drugs that could be flushed down the toilet, depending on the circumstances. Those, I don't agree with those cases, but they're out there. So those are exigent circumstances. Those are the only two exceptions. Now they're trying to create a third at the urging of Joe Biden, which is really inappropriate. Like, why does it matter if Joe Biden urges the Supreme Court to rule a certain way? That's just bizarre. But they're trying to create this so-called community caretaking exception. I think I did a video on this, and that's just a bunch of BS. That's like when that's like that gun control law that we talked about. The Firearms Protection Act, Firearm Owners Protection Act. Like, yeah, okay, yeah. So that's like the community. It's like stop resisting. I'm caretaking you, and community caretaking. That's like this screw the homeowner exception. That's what that is so basically a catch-all. So they thought they had some reason that. What they're trying to extend it to is guns. So it's a community caretaking, so like these red flag laws, or some family member says that, their brother has, he's a gun nut. He's got all these guns and they're really worried about his mental stability. And so then the cops go in without a warrant. And then after the fact, when they get sued or there's a big problem, they claim community caretaking exception. And that's not a thing. In reality, if you trace back in the case law where that came from, it came out of two different cases, and they both had to do with automobile inventory searches, which is another BS thing that came out of the law, where if they arrest you, they have to take care of your stuff. It's for your own good. They inventory it and stuff like that. That's where it came from. So it had to do with vehicles. It didn't have anything to do with your house. And law enforcement, that's what they do. They try to weasel some way, and prosecutors and these liberal mayors, they try to, and sheriffs. These counties, they try to weasel any way they can find, any kind of legal gymnastics that they can do to try to make something that they did that was illegal look legal. They'll do it. And I've had them try this community caretaking thing on me before, and they get away with it. Now that's a long story of why and how that happens, but To make a long story short, no, they do need a warrant. Jeremy, the peasants are always held accountable. The government is never held accountable. It's pretty much right, unless the government wants to hold themselves accountable. That's usually the only time cops get in trouble, in my experience, is if for political reasons the leadership or other cops want to throw somebody under the bus. So that's not always, but a lot of times when cops do get in trouble, it's because they got thrown under the bus for political reasons, which ironically a lot of times is unjust in and of itself, because sometimes you'll have a good cop who gets thrown under the bus by bad cops and set up, made to look bad. And I've looked at several of those cases. And yeah, so it's sort of like playing with fire. Yeah. So yeah, stop resisting. I'm caretaking you. It's sort of like protecting and serving. When you don't want to get caretaken. Yeah, Bubba, the 9 scariest words in the English language. I'm from the government and I'm here to help. Great comments. I appreciate all those comments, you guys. Daniel, well, apparently the First Circuit thinks the community caretaking loophole is legit. Yeah, I guess the First Circuit is where the case that's before the Supreme Court came from. I didn't recall that, but I'm speculating that based on that comment. And I've gone over that case. Is it the Paul? What is it? Palmieri or something like that. That's at the Supreme Court right now. And it's not legit. It's not legit at all. In fact, all this, and it's been both Democrat and Republican judges have created all this stuff, like all the Terry stops and all the Terry case law that came after that. That started with the so-called conservative judges. But all they have to do is add guns into the equation, and now the liberal judges also they want to support the government over the individual. Gunny, until we chop out half the laws that give government pretext for contact with citizens, will always be in jeopardy. Well, when you say that, what are the laws that give the government pretext for contact with citizens? And I'll leave that up. So what he's talking about is pretextual stops. So say I'm a cop and I go into a high crime area and I sit there and I watch a stop sign. So I see a vehicle not come to a complete stop, or every vehicle I see that doesn't come to a complete stop, I go stop them for running a stop sign. But I know that I'm in a high crime area and I know that there's going to be a larger percentage of people. And this is where they get into racism, right? Into what do they call it? Used to call it profiling, racial profiling. You haven't heard that phrase in a while. Because why? Because they're busy racially profiling white people. That's why. So that used to be a thing. And I remember writing a memorandum on this at the Department of Justice on pretextual stops. And so to get back to your question, chop out the laws that give the government the right to make these stops where they're technically pulling people over for traffic laws, but they're really searching for warrants and smelling for drugs, things like that. Those are pretextual stops, and they have all sorts of statistics that say, well, we bring in this many rapists and murderers every year across the country on regular traffic stops. So where it comes from is from the case law, from the judiciary, from legislating from the bench. It hasn't come from Congress, hasn't come from state legislatures. It's come from the federal judiciary. And what do you do about that? Well, just like is happening here with the gun owners of America, putting their money where their mouth is and challenging the government. That's what's going to have to be done. Get it back up there to these federal circuit courts and to the U.S. Supreme Court. And it absolutely should be unconstitutional to go into. I mean, let's say that let's say they go into, all right, since the minority of the month right now are Asians. Let's say we go into, well, really, that was one of the first minorities that our government officially started discriminating against is the Asians. In fact, our very first possession statute was really just to stick it to the Chinese in San Francisco. They liked opium. They had these opium dens, and so the very first possession statute in this country, it's like 1870s, was to outlaw opium, to try to stick it to the Chinese in California. So let's say that now in 2021, the police are going to go into Chinatown or into an Asian area in any city in the United States, and they're just going to sit and wait and watch until the Asian drivers pull up to the stop sign and don't come to a complete stop, and then they're going to go search their cars and run the drug dog around their cars. I mean, yeah, that wouldn't happen now, because now we are making it okay to racially profile, but just has to be the right race. But all pretextual stops really should be illegal. I use this example a lot. What would Thomas Jefferson think? Because at the time, 1789, 1790, around the time our country first began with our new Constitution, with our Bill of Rights, what would Thomas, we didn't have cars, obviously. So that's been sort of the theory of why, you need Justice Ginsburg to legislate from the bench, because our founders didn't know that we were going to have all these cars and these new legal issues that would pop up. So that's why the Constitution is this living and breathing document. So then one would ask the question, all right, well, what would Thomas Jefferson think? All right, let's say he's on his way to the Capitol and his stagecoach gets pulled over by the police on the way to the Capitol. Well, it's impossible, because that wasn't a thing. That literally wasn't a thing in our society. We were not like that. That was created somewhere along the way because of fear. All the old people getting scared. They were scared of the shadow. So we need a law for this, that, and the other thing. Everything needs to be illegal. And the politicians are always older. And that because they're scared, everything has to be illegal. So we created ourselves into this police state, but still, why do we really need police to enforce traffic violations anyways? When you think about it, even using technology now. All right, if somebody's speeding or if somebody ran through a stoplight, well, we have red light cameras. Why couldn't a police officer or anybody could just be a DMV employee driving around with the camera? So if they catch somebody speeding, boom, it gets their license plate and it sends them a ticket. No, they want to be able to pull us over, pull us out of the car, see what we have in there. It's always been about more than that. And it should have been challenged from the very beginning. And I don't care if they catch, 50% of all murderers with pretextual stops. I don't care. Because, why? Because freedom is scary. That's why. Because I'd rather not have to put up with it. Yeah, Bubba, the founding fathers, I do believe they would be shocked at what's going on today. In fact, we look much more like a George Orwell book than we do anything resembling that our founding fathers began. So it is now 8:17. I was given strict instructions to finish by now. Dwight. No, Dwight, thanks I'm glad you're watching, bro. But no, I'm not going to run for governor, because I wouldn't want to be governor in 1,000 years. And think of all the stupid stuff that they have to constantly concentrate on. And apparently people want to be forced and told to wear a mask and all this. I mean, I don't know. Maybe I'd get impeached if I was the governor, because I would have just used every opportunity to lecture the media on the Constitution. In fact, our governor has done these stupid campaign videos every day under the guise of being a COVID-19 update. Like, we still need those every day. It's been free campaign advertising, free publicity. I would have spent my time maybe teaching school children, because their teachers weren't in school, about the Constitution, about our founding fathers, and about George Mason, and about, we have to go over the Federalist Papers, which students used to study. And, I probably wouldn't do anything that the lobbyists would want me to do, and I probably wouldn't last long. But I would have had fun doing it. But it doesn't matter, because I've got to work. Like most of us, I have to earn a living, and I have things to do. I can't just play politics. See, if you were an independent, then you would be mentally qualified to be a governor. Well, I'm speaking at the Independent Party Convention Saturday, April 10th. Well, I'm co-speaking anyways, in Flatwoods, West Virginia. Duke, we could use more teachers. Yeah, don't get me on the teachers topic. Let's see. All right, so where was I going with this? Yeah, that's right. I got to go. I was supposed to go at 8:15. Wednesday, if the creeks don't rise, I was planning on doing a live video, same time, 6:30, with Lackluster, who runs one of the really successful, one of the popular, First Amendment auditing commentary channels on YouTube. And I really enjoy a lot of his videos. I mean, hopefully we're going to have some discussion about a lot of the First Amendment issues. I'm looking forward to that on Wednesday. So hopefully that's going to be Wednesday. If not, we'll do it another time. But thanks for watching. I also I have an update in the school bus driver case in Jefferson County, where the school bus drivers who were at the Capitol on the 6th and got suspended. I have an update in that. Just have to do it another time. So thanks for watching. I'll leave you with this, something I saw from Thomas Paine. The supposed quietude of a good man allures the ruffian, while on the other hand, guns, like laws, discourage and keep the invader and plunderer in awe, and preserve order in the world as well as property. The same balance would be preserved were all the world destitute of arms, for all would be alike. But since some will not, others dare not lay them aside. In other words, gun control only stops the law-abiding citizens. The criminals are not going to lay their guns aside. Horrid mischief would ensue were one half the world deprived of the use of them. So it's not a reality that you can get rid of all guns. Not going to happen. All we're debating is whether to disarm the law-abiding citizens. And for obvious reasons, that would be a disaster. So thanks for watching.